Honourable Dr. Wayne Mack.
Thank you. Mr Chairman, I've been listening carefully to the previous speaker. I know is concerned about rights and issues, and I know the training and experience she has had. I feel there needs to be a balancing point put here, and I know other members highly experienced in criminal proceedings will be taking a call on this on part of the government as well. But I do think, for the benefit of the House and indeed for the record and for those members of the public listening, it's worth noting the terms of the provisions of Clause 9 and then the protection set out in particular in Clause 6. The first point to note is that Clause 9 actually starts, AVL must not be used in any criminal substantive matter unless a judicial officer determines, and then there are criteria. Firstly, sections 5 and 6, in practical terms, section 6. And second, B, taking into account whether the parties to the proceedings consent to the use. Now, the opposition, Ms Leanne Dalzell, would say that the situation of the parties is absolute. They have absolute determinative power as to whether or not there should be an AVL hearing. And I would suggest, in fact, that it ought not to be an absolute right at all. It is something to be balanced in the circumstances of the case. And one should also look at the criteria that are set out in section 6. The ability of the defendant to comprehend the proceedings, the ability of the defendant to participate effectively in the conduct of his or her defence, the ability of the defendant to consult or instruct counsel privately, to access relevant evidence, and to examine witnesses for the prosecution and other matters set out therein. Those are high-level protections which judicial officers have to consider. And I want to come back, however, specifically to the provision, the way that Clause 9 is actually constructed. Because this is actually, I think, the fundamental point. The operative direction to the judicial officer is that AVL must not be used in any criminal substantive matter, and then there's an exception to it which has two criteria to the exception. Now, as legal scholars will well know, that effectively sets an incredibly high threshold to the situation. So the judicial officer would have to be totally satisfied that, in essence, the defendant would not be prejudiced on this issue. And naturally enough, this would be an issue that would be dealt with by a hearing where both with counsel to make submissions, both counsel for the defendant and counsel for the prosecution, as to whether or not this is an appropriate step to make. I agree it is a significant change. I agree that it is one to be approached with caution. I would suggest, however, to the opposition that the structure of the legislation is such that those very things that the opposition have raised have been taken into account. And I'm sure that's why the Attorney-General, who Ms Dalzell well knows is highly experienced in criminal law matters, deeply understanding of citizens' rights, would have taken the provisions into account. And I want to just point out, it is the Attorney-General's judgment, based on his experience, as to whether or not the relevant notice under the Bill of Rights should be issued. It's not an issue for whether or not a civil servant thinks what is appropriate. It's not an issue for whether another agency thinks it's the Attorney-General's judgment that is at stake. And I just want to conclude on this point. This government has made sure that we have a highly experienced lawyer as our Attorney General, one that is deeply experienced in litigation. In contrast, Mr Chairman, the other party that when they're in government actually chose for a number of years to have a non-lawyer as the Attorney General. That, I think, tells you a great deal about their deep respect for the institutions of Parliament and indeed the deep institution of the Attorney General. They were prepared to run roughshod over that issue, and they should actually be embarrassed and actually just stop interjecting, except for someone who knows absolutely nothing about the law. And so, Mr Chairman, may I say this? I think the opposition would do itself a favour if they carefully analysed the legislation to see whether the balance of rights and protections is properly taken into account.
Dr.